Welcome to our webinar this evening, Working with Your Professional Educator's Attorney. We are delighted to have Mike Sheppard, who is our counsel for the Professional Educators of Tennessee. Mike Sheppard attended Morehead State University as an ROTC cadet, moving on to Salmon P. Chase Law School, where he earned honors in criminal trial practice and Dean's List designation. Mr. Sheppard is passionately dedicated to the empathetic and knowledgeable advocacy of its members and the teaching professions. And without further ado, I'm going to change the presenter to Mike Sheppard, and he will begin this presentation. Thank you for being with us this evening.
Welcome to our session on working with your lawyer. Oftentimes, teachers wonder exactly what their professional insurance covers and how does that involve our lawyers and what do we do and how do you relate to us. So at Professional Educators of Tennessee, we are dedicated to improving communication with our members, and those members consist of directors, principals, and teachers. And each one of them have different questions in different situations at different times. How do you work with your lawyer once you have a situation where you need advice, legal advice? Sometimes that advice is quick, maybe as simple as calling a professional educator or lawyer and that lawyer simply saying, okay, well, I've been asked to talk about evolution today as it's compared to the Bible teachings, what can I do and what can I not do? Other cases may involve much more involved accusations, reprimands, legal liability questions. A lot of the questions we get come from the athletic area, but just as many of them come from teachers that have special ed students and have to deal with problems in the classroom. So it's better to be prepared to deal with your lawyer before it happens, because it's going to be a little confusing, and quite frankly, it's an anxious time. So what we try to do is build a relationship early on with each of our member clients. So let's talk about building a winning and effective relationship when you're in a position, you're anxious, and you need support from professional educators. First of all, our attorneys will ask you basically what is your objective. If it's a reprimand or a termination or a legal liability situation, those questions and objectives will be totally different. If you've been accused of criminal wrongdoing, it may involve a very simple objective, and that is, I didn't do it, this is wrong information, this student and their parents don't have their facts straight, and I'm actually being a scapegoat. Or if the facts are somewhat true but they've been distorted, our objective may be to gather evidence, but in very short order, lay the groundwork for finding you not responsible for what occurred. If it's an employment-related incident, that's really where we get into laying down the objectives as far as, okay, do you want to remove the remand or a reprimand? Do you want to document your personnel file with additional evidence? What is it that you're trying to achieve? With that in mind, the lawyer will sit down and create a strategy toward achieving that objective. If there has been, that may involve getting a copy of the personnel file. It may be sitting down with the administrator or whoever it may be, or a parent, to discuss what the issues are. Can this be resolved fairly and equitably and cooperatively. Those are the first questions you want to ask. So it's not always the best idea to throw a lawyer at the situation and say, go after him. That may not be the best advice. So with our staff, in conjunction with the attorney's perspective and researching the law, whether it's a bill or whether it's the ethical rules or whether it's the board policies, we always want to keep in mind that there is a common sense approach to protecting our members, and that can't always give way to hard-nosed legal positions. Now, having said that, there are times when we do have to do that, but discussing it up front with the member and with the client is very, very important. What is it you want to achieve? Early on, the attorneys will discuss with you gathering the documents that will help your attorney understand your case and ultimately aid that attorney in presenting evidence on your behalf. That could be emails, it could be actual memorandums, it could be letters, it could be items from the personnel file, it could be anything that is probative, and probative means basically something that goes to the heart of the matter. So we want to know what documents exist, first of all, for the benefit of the attorney to design a strategy that protects you and defends you, and in certain cases even prosecutes further your position, which may deflect or defer responsibility for something that's gone wrong to another person. Again, we're not looking for somebody to blame, we're looking for the truth. And the truth sometimes requires a lot of detail work. So at the very beginning, you can expect your attorney to ask you what you want to achieve and what documentation exists to support your position. So, and I'd like to emphasize the importance that sometimes these investigations, which may result from claims that come from another person, may go on for a while. So it's very important that you maintain that sense of documentation and record keeping throughout the handling of the investigation. Oftentimes I'll see people kind of, well, I've given the attorney what he or she needs to protect me. Well, there's stuff going on all the time, every day, that you need to try to capture and relay to your attorney. So it's real important that you talk to your attorney often, and keep in mind, and we'll talk about this a little bit further in the presentation, everything you tell your attorney is confidential. That attorney-client confidence privilege is sacrosanct. It's very hard to break in all jurisdictions. It's the same privilege you have with your doctor, with your psychologist, with anyone. So it's very important that you feel comfortable with your attorney. And that means getting to know the attorney enough to maintain a trusting relationship. And that only comes from working together as partners toward achieving the goal that we want to achieve. I can't stress that enough, that this is a partnership and not a situation where an attorney takes over and does works magic or waves a magic wand. It's got to involve you, the professional educator member, and it has to be regular, it has to be consistent. So a partnership has to be maintained, communication has to be good, it has to be substantive, you have to keep your eye on the ball, where do you want to be, and you want to be able to document things as they occur. Is there any questions anybody would like to send to us at this point, feel free to do so. Bethany, let me know if anyone does have a question, and I'll stop and answer it during the presentation, okay?
If anybody has a question, just type it into the question chat bar, and I will read that out at the appropriate time.
Okay, I'm going to proceed. Again, I just mentioned the attorney-client privilege. When you talk to a Professional Educators of Tennessee lawyer, that lawyer represents you. They do not represent professional educators. They represent you. So again, it's essential that you're comfortable, that you know that this attorney is going to do what's in your best interest, that attorney puts you as a priority, that he will ask you questions, tough questions sometimes, that seem to be kind of like cross-examination, but good attorneys will tell you that up front. I'm sorry, I'm going to ask you a lot of questions. It's important not to be defensive or to even infer that the attorney is drawing the wrong assumptions until that attorney has all the facts in front of him or her. So there's a certain, so your job at the beginning is to get that attorney educated as to the facts of your case. Now, does that mean every detail? Probably not. But as you go down the road on your case with the attorney, you'll get a feeling of what that attorney needs to know and what he or she doesn't need to know. And when in doubt, call the attorney. Don't sit and wait. If you're concerned or anxious or you have a question or something's happened that is intimidating to you or you just don't know what to do, pick up the phone and call the lawyer. Now, let's back up to the beginning just for a minute. Even before you start this hand-in-hand relationship with your lawyer, you have to recognize the need to call us. If I can say one thing that's real important through this presentation is call us early. You know, do not wait too long to pick up the phone. You're better off, you know, letting us know what's going on at the first indication of concern or problem. Evidence goes stale, things happen that get in the way of reaching a fair resolution otherwise. So it's very important to, when in doubt, call us, or, you know, that's why we're here. That's why you belong to professional educators, and that's why we have staff attorneys, and we have other educators on staff that help us with administrative issues that don't technically fall into the legal area but assist the attorney in knowing what the process in that particular school is. There may be different rules, but you will find that the attorney will use the statutes, the education statutes, as a reference. That attorney will also use the board policies and will also use rulings that have occurred in the state with similar issues that you've been involved in. So there's a great deal of preparation that goes into representing our members, whether it's an employment-related issue or whether it's under your liability issue or whether you have to call and ask for a bond because there's been an arrest involved. So we don't like to talk about those things. Most people are never involved in those things, but you have to understand in this day and age, people can say anything. We're kind of suit happy in this country, and there are people that like to blame educators for everything that goes wrong in their lives. So that's not to say that we don't have legitimate concerns by parents, but our members are very important to us, and to protect them adequately, we like to do things like this webinar to help them be prepared if and when, in the unlikely event, something like this happens. That's what insurance is all about. Do not discuss your case with anyone. It's essential that you do not discuss your case with anyone. I don't care if the person's your best friend across the hall, or in the case of a administrator, you may be on the phone every day with someone that you talk to or see on social occasions, or your son or daughters may be on the same team. It's very important that you keep your case quiet. Anything you say will be relayed into the record, likely, and rumors start and people talk. That's just the way it is. Conduct yourself professionally and proceed as normal as you can during the investigation phase, no matter how minor the investigation is, whether it's a reprimand or whether you're involved in a grievance process, whether you're involved in a criminal investigation. Those rules apply all across the board. So I can tell you some nightmarish stories of folks that have gotten onto their school computer and shared evidence with their relative 2 states over. Not smart. That is just, it can be misconstrued, misused, and no one has a right. And if you do that, and you may waive some confidentiality that you have with your attorney if you go out of the room with your attorney or off the phone and you share confidences with everyone. Some people could basically say that you're waiving your attorney-client privilege by revealing all of that information to someone else. So very important. Any questions yet that have been sent in?
Yes, I have a question. One has asked, says that I'm very intimidated by lawyers. Will other people know my business?
Absolutely not. And I'm not sure what business is defined at in this situation, but it's very confidential. Lawyers are intimidating. The education lawyers and the lawyers that we commit to representing you know about education, know about the pressures that you go through, and know about the anxiety that is associated with trying to do a good job but yet being accused of something that either you didn't do or may have been misstated. So our lawyers are a little bit a cut above the normal lawyer you see on TV. They're very experienced in education and business, but they also have personal skills that include empathy and dedication to understanding what you're going through. So again, they will build a relationship with you, attempt to build a relationship with you, and you should try to do the same. And that means being very open with them and building trust. So again, mum is the word. Doesn't mean you have to lie. Do not lie, and don't ever misstate anything regarding your case. But it's your right not to say anything, and that's in your best interest. Witnesses, again, this is common sense. Every one of our members has the intelligence to understand that, cases are made up of testimony, of documents, of written evidence, and so it's important to decide and share with your attorney who can corroborate exactly what's happened. I mean, I don't care if it's a baseball player, student who was injured on the ball field because a coach was not where he or she was supposed to be. Who was there on the playing field? If there's claims of unlawful touching or improper touching, or you know, a coach is all he or she's trying to do is monitor the locker room, and some student doesn't like that when he's simply trying to keep any fights or things going on in the locker room, and he goes home and comes back to school and somebody makes some unreasonable charges. We need to know who was there. We need to know who the students were. Oftentimes that's difficult because they're minors, but you need to let your attorney know who was there and who we need to possibly talk to refute the charges. So again, I don't want to scare everybody that's attending this webinar. Sounds like this happens every day. It does not. Just happens enough to worry our teachers, and it happens enough to have insurance for it. So, and that's why you have your membership with professional educators. And again, beyond legal representation, we have very experienced people on our staff that have been teachers and know what it's like to be in your situation. Do not use your school email or school phones. Use only private email and private cell phones. Very, very important. If you're going to maintain the confidentiality with your lawyer, that's essential. And you'll find that the attorney will talk to you early in the morning and sometimes late at night, because that's the only time teachers and administrators and educators have time, because you're very busy during those school hours. So be prepared to be flexible. Be prepared to call the attorney's cell phone. Watch your texts and your emails, and in this day and age, there's no reason why good communication cannot be maintained. So, you know, I think it's pretty obvious why you do not want to use school equipment. You know, that is, can be, depending on the situation, you know, can really work against you. So on to the next slide here. Document all facts and activity that occur during the investigative phase. Take copious notes of meetings. Oftentimes during the investigation process, you will be called into a meeting. It's either with your superior or maybe a colleague. I don't always recommend recording meetings. That is definitely your personal right to do so. As an attorney, however, we're not ethically obliged to instruct our clients to record conversations. That does not mean you cannot make that decision yourself, but the Board of Professional Responsibility in our ethical code prohibits us from instructing clients to record meetings, and we are not allowed to record meetings. So, so that is an ethical no-no, but that does not apply to the client as long as you're a party to the conversation in Tennessee, and you know, you're able to record those meetings. I like to see notes taken. I like to see, for a lot of reasons, it gives a lot of it gives the image to the person you're dealing with that you're taking this very serious, and that you're trying to do what's right by documenting the entire situation properly. Any other questions at this point?
I don't have any more questions.
Okay, thank you. people may find this to be kind of a paradox, but learn to trust your lawyer. We know all the lawyer jokes, and we know all the the TV situations and the shark mentality and all of that, but that is kind of really out of context and has been twisted. It's funny, but it's really in your best interest to trust your lawyer. Now, if that lawyer doesn't earn your trust, then you need to tell them that. That lawyer has to give you advice after being apprised of developments, and sometimes that advice is not what you want to hear. In other words, a case that is handled by a lawyer changes. It takes on a life of its own. And you may go into the case with certain evidence, and midway through the case you may acquire more evidence that causes you to adjust your thinking and your strategy. No attorney is worth their salt when they say they get a hard-nosed position in spite of the developing evidence. That is not in your best interest. So always remember that a case changes proportionate to the development of the evidence. Evidence trumps all other positions. So as that evidence trail develops, testimony is gathered, and the investigation is completed, that has to be evaluated, and on those facts and the gathering of that evidence, the attorney will advise you as to what you should do. And there is what I just said. Your case may change as the evidence develops. Again, the worst thing an attorney can do is take a hardline stance and let their ego get in the way. That may not be the best situation for you. So you are the client. You're kind of the boss in many respects, and you've got to challenge your attorney. If that attorney is, I don't think we have anybody on our staff that does that. As General Counsel, my job is to make sure that I or anyone else or myself puts you first. The fiduciary responsibility, the attorney-client privilege has to prevail. More than anything, you need to remain calm. The situation that you're in, oftentimes you may lose sleep, you may be stressed out, and no one is ever going to tell you that, well, don't worry. They may tell you that, but that's easy for them to say. They're not in your situation. So work with your attorney. Make sure that you have a strategy. You know what your objectives are. There is good communication between you and your lawyer. And again, the trust has to be there. And report your situation early. So with that, I'd like to conclude the presentation.